The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Thank you, Ms. Lindsay, and thank you, Mr. Husky and Mr. Brown, for participating in this oral argument via Zoom, which is being broadcast live so that the public can view our court proceedings. This way we maintain, or we fulfill our obligation to keep the courts open. We will conduct the hearing in the same manner as if we were all together in the courtroom. Each side has 15 minutes, and I understand Mr. Husky for the appellant has reserved some of that for rebuttal, and the clock will be adjusted accordingly. Unless there are any announcements, I'll ask Ms. Lindsay to call the case.
Coffee County, Tennessee versus Carl Spining et al.
All right, Mr. Husky, you have the floor, and good morning.
Your Honor, I'm Bob Husky of the Coffee County Bar. Glad to be in front of this court again, but it's the first time I've been in front of it by Zoom, so I'm a little bit apprehensive about that, but we'll do the best we can.
I don't think anything can slow you down or scare you, Mr. Husky.
You didn't see me around technology. We're appealing a dismissal under 12.02 subsection 6, and y'all know the standard on that, so I'm not going to spend any of my time talking about the standard. It's about it's a malpractice case against Carl Spinning and his firm, who represented the county in an underlying case, and the issue in the case is the statute of limitations. The underlying case was the case of Keeling versus Coffee County. It's a case that alleged roughly a dozen, 10 or 11, according to the different times he said in the pleadings, different PEPFAR violations, only one of which could justify a wage damage award. The malpractice involved in the case, it occurred, two malpractice occurred by the defendant firm in the case. The malpractice itself is a combination of two things. One, the failure to object to a defective jury verdict form, and two, that in and of itself was not a violation of the standard of care. That was a trial tactic. Both sides, the defense and the appellant, agreed with that. That was a trial tactic. But that, combined with the stipulation that was made that we didn't learn about until we got the Court of Appeals ruling in the case, that if the jury found a PEPFAR violation, the judge would go forth and award wage damages. There was no problem with the jury verdict form not objecting to it, because even though it was a defective form, the plaintiff still had the burden, in somebody, either the jury or the judge, had to find that a PEPFAR violation that would award, that could constitute wage damages, occurred in order to award wage damages. However, in this case, the jury never found it, nor did the judge, because of a stipulation that was made between Mr. Spinning and Ms. Keeling's counsel, that if the jury found a PEPFAR violation in a case where there was approximately a dozen alleged violations, only one of which could justify those wages, and that was her layoff. She alleged that a letter of reprimand that she got from her supervisor for the PEPFAR violation. And she alleged essentially every office policy and thing he did for a period of time was a PEPFAR violation. Then 5 months later, during the downturn of the economy, when there was no building going on and no work for a permit clerk, and she got laid off, she alleged the layoff was a PEPFAR violation. There would not have been a problem with the stipulation, making a stipulation, if it had read something to the effect, if the jury finds that the layoff was a PEPFAR violation, then the judge goes forward with wage damage determination. That would have been fine, but that's not what occurred. We've got, and we know the jury didn't find the layoff was a PEPFAR violation, because we've attached attachment 2 to our attachment 1 to the reply brief we filed is a copy of that jury verdict form. It very plainly, they were not asked to find whether or not the layoff was a PEPFAR violation. They were just asked to advise whether or not and find whether or not the plaintiff had proved a PEPFAR violation. There was another failure and as a result, after the jury found a PEPFAR violation, the judge went forward and ordered roughly $500,000 worth of damage in wage damages. Then the county had to decide whether or not to appeal. And when we made that decision to appeal, our counsel never told us about the stipulation he had made, because if we'd known of that stipulation, we'd never appealed, because we'd have been out. And as it turned out,
Excuse me, Mr. Husky, I understood you to say if the county had known about the stipulation, the county would have never appealed the
Yes, Your Honor.
underlying case.
That's exactly correct. He told us that they could always award more damages, but the jury hadn't found that and so we didn't know about the stipulation we had. And then when it went to the Court of Appeals and they ordered more damages, then we ended up with a payout of about twice the $500,000. Our payout was $994,000 and some odd dollars after the added to it, and that was $500,000 right there. So there were two actual malpractices. One, when you combined that waiver of the jury verdict form with the stipulation, and then two, when we had to appeal, and we talked about a lot of things, but he never told us about that stipulation. And we would have never agreed to never appeal, because we couldn't have won, and we'd opened the door to what happened to us.
When was the decision to appeal made, though?
The decision, I don't recall the exact date it was made, but the decision to it was made after the judge awarded the roughly $500,000. And what prompted it, in the post-trial motions, Mr. Spinning was arguing that the jury didn't find the layoff was a PEPFAR violation, just that there was a violation. And the judge says, no, the jury found it. And so we checked the jury verdict form, and you've got it before you. They clearly didn't find it. So what that looked like? It looked like the judge had made an error. He was in error. And what do you do when the judge is in error? You don't sue your lawyer, you file an appeal. And based on that, I would respectfully suggest nobody can look at that jury verdict form in a case that had 11 different violations alleged, only one of which could award wage damage, and say the jury found that the layoff was a violation of PEPFAR. And so we were forced to appeal to recover, to save our $500,000, because we knew the jury hadn't found that. Judge thought they had, but the jury verdict form was is in conflict with what Judge Smith said. So we thought he made an error, which happens. And so you appeal. That's what an appeal's for. It was not until we received and on legal malpractice, it's adopted the discovery rule basically out of medical malpractice. It's two-pronged. One, damages occur. When did we suffer damage? No doubt about it. And the defense wants to say this is when the statute began to run, because it's when we suffered the first damage. That's not the law, but we suffered damage on July 7, 2017, when the trial Judge Smith entered a wage damage against us of roughly $500,000. Then on September 18, 2018.
Mr. Husky,
yes.
Could you pause a minute? I noticed Judge Clement is off the screen, and I just want to make sure that he is still participating in the oral argument. Can you, Ms. Lindsay, will you hold the timer for a second, please? Pause the timer.
Excuse me. Excuse me, Don.
Jacobson, is Judge Clement still on with us?
No, he
Okay.
is not in the meeting. I was about to say something, but then you.
Okay, thank you.
Mhm.
Let's pause a minute. Let Judge Clement rejoin us here.
That sounds good. Let me stop this.
So, Mr. Husky, it wasn't you, it's us. You seem pretty practiced at this.
You don't realize how much blood pressure I've had dealing with. Hey, if you read my motion to get an oral argument in person, you know, I spelled it out in detail.
We're all going to have to be drug into the century, I'm afraid, but drug we will be.
I was focusing so on Mr. Husky, I didn't even notice Clement was gone.
I could make some humorous comments about that because I like Judge Clement, but I
Yeah.
might not ought to.
Well, I was about to too. I know the recording stopped, but you have to be.
And the question I was going to ask you at that time, and we're going to give you a little more time because of my problem here. I made some notes. It said the county began reviewing court documents and investigating the decisions made by Mr. Spinning. Specifically, the county went to the clerk's office and obtained a copy of the jury verdict form. After reviewing the jury verdict form, the county concluded that the form reflected exactly what Mr. Spinning had represented to the county. Shortly thereafter, the county authorized Mr. Spinning to appeal the decision. So I'm going to have a complex question here. One, is that generally correct? And two, if you knew this, then why did you appeal? Because I understood.
Form, which is the way to find out what the jury was both asked and what they found.
Gotcha.
And judge was saying one thing and our counsel was saying another, and between the two, looking at the document, and if you look at it too, you'd agree that the jury didn't find that, but the judge was saying it did. And so we thought the judge made an error, and for that you appeal. You don't go after your lawyer.
Gotcha. So it's the stipulation of, it is the important fact that the county was unaware.
Unaware of. The day I knew that was the day the Court of Appeals opinion came out, and it was emailed to us. And I read that, and I remember sitting in my library reading it. The next time the mayor was over, I pointed it out to him. We never knew about it. And no, we would not have appealed. So we know there was another $500,000 right there that we got hit with.
Did anybody with the county read the brief that was filed in the case on behalf of Coffee County?
I read the brief that Mr. Spinning submitted.
Didn't that
He
brief
sent me a copy.
have that stipulation in it?
Not what I read, didn't. Nah. If it did, it was in a changement that I didn't see, because I would never, we'd have halted that appeal immediately if I'd seen that. Because just like the.
But it's clear though that the stipulation was revealed in the transcript, which was filed.
I didn't go read the transcript. That was filed later after the appeal was in process.
Correct. But
I went to the clerk's office to merely get and ask for the jury verdict form, because you had the trial judge saying one thing, trial judge and plaintiff's counsel saying one thing, and our counsel saying another. So you go ask and get a copy of the jury verdict form, which they gave me, and it clearly, you've got it in front of you, says what was reflected that Mr. Spinning was correct. So that was not investigating Mr. Spinning. That was just seeing which one was right on it, because I knew that's a simple way to find out. And there was no transcript filed at that time, and I had no reason to read it. I wanted to see what the jury was requested to find and what they found. The time that's still showing for me, that's in my main part. That's not with my rebuttal
Right.
time.
You still have your full rebuttal, and I'm going to add 2 minutes to your opening remarks because of the technical problems with my computer. You and your client should not be shortchanged because my
Thank you,
computer
Ron.
shut me down. So, Miss Lindsay, please add 2, or Mr. Jacobson, please add 2 minutes so Mr. Husky can fulfill his opening statement.
So basically, Your Honor, we had two acts of malpractice. One, when he made that stipulation in combination with the defective jury verdict form. And if the stipulation had referred to the right of alleged offense, the layoff, that would have been fine. But it didn't. It just said a PEPFAR violation. And then the second one, when we were fixing to appeal and weighing it back and forth and discussing it with Mr. Spinning, he never told us about that stipulation. And that's information we very much needed to know. Because you see the difference, it basically doubled the judgment when we went up. And so consequently, then, and under the legal malpractice, it adopted the same standard that was existent for the medical malpractice. And that's two-pronged. One, the injury or damages. That occurred on two occasions in this. One, first, when the trial judge entered the wage verdict on July 7, 2017, which the defense and the trial judge treated as the accruing of the statute of limitations starting to run. But the second prong is the reasonable discovery. And we did not reasonably discover the malpractice that cost us damage until September 18, 2018, when we received that Court of Appeals opinion and learned of the stipulation. And I can't think of anything that would have been more important for us to have known to make that decision. And anyhow, as a result of the agreement he made, combined with the failure to object to the jury verdict form, and then on the appeal, not advising us about that stipulation before we made the decision, Phil, we got hit big time with roughly $1 million.
Mr. Husky, was the brief filed by Mr. Spinning shared with you shortly after he filed it, or at the same time or shortly after he filed it with the Court of Appeals?
He sent me a brief to review, and I reviewed it and made some comments to him about it.
So you reviewed the brief before it was filed with the Court of Appeals? But
at least what he first sent me.
right.
I because somebody raised a question about, did it say in there about the stipulation? What I read, what was sent to me, didn't say anything about stipulation. I never saw anything in the case about a stipulation until I saw the Court of Appeals opinion on September 18, 2018. And I believe under Rule 12, that statement of fact is accepted as true by the court and by the defendant, that is taken as fact. And it is a fact. That's because I know that myself.
All right. Thank you, Mr. Husky.
Were you sent the final brief? Were you sent the brief that he filed?
Off the top of my head, he probably did. Off the top of my head, I can't say yes or no, but I know I never got anything that said anything about a stipulation.
All right. Thank you, Mr. Husky. We'll hear from you further on rebuttal. And Mr. Brown, I hope you understand I felt an obligation to give Mr. Husky some additional time because the disruption was my computer's fault, not his. So, Mr. Brown, you now have the floor and you have 15 minutes.
Thank you, Your Honor. May it please the court. I'm Gregory Brown of the Knox County Bar, representing here the defendants. And as Mr. Husky ably described the issue, it's really a simple statute of limitations problem for the court to resolve. And I think Judge Davies did a good job with it. The key dates are that a partial judgment was entered against the county on January 26, 2017 for $30,000. Motions for front and back pay to be determined by the judge. That's a key point. It was to be determined by the judge. That motion was filed January 25th, 2017. The county noted in its brief that the county attorney attended that hearing on the motion for front and back pay.
You say the county attorney attended it. You're not referring to the attorney for the county being Mr. Spinning, but the office holder, the county attorney.
Yes, that's my understanding, is that Mr. Husky did attend.
All right. Thank you.
That hearing. There was a motion for a new trial in February 24th, 2017, which argued that the verdict was confusing because there was no place on the verdict form for front or back pay. Which is, again, is another key point. There was no place on the verdict form for the jury to award front or back pay. That was always reserved for the judge in this case, and that is the stipulation that Mr. Husky is referring to, is that the trial judge would make the award of front and back pay. And of course, July 7th, 2017, a judgment for approximately $450,000 was entered against the county, which included the front and back pay awarded by the trial judge. A question was asked earlier about the notice of appeal. I know that the Court of Appeals file stamped the notice of appeal on September 11th, 2017. I don't think that was included in our record before the court, but I believe that the Court of Appeals can take judicial notice of its own files for that purpose. So I think that date is before the court. So it was sometime between January 25th, 2017 and September 11th of 2017 that the county attorney went to the clerk's office, began investigating, looked at one or more documents, at least the verdict form, again, which had no place on it for the jury to award front or back pay.
And was that the stipulation that's at issue, that the parties stipulated that the jury form wouldn't include that, or
Yes.
was that
Yes, and I mean, to the extent it's a stipulation, the law requires that the trial judge determine front pay. And there is conflicting case law, and if you note, if it's quoted in the briefs, the language on the transcript where the attorneys discussed that with the trial judge, they talked about the fact that there was some case law that suggested the trial judge could determine back pay, and based on that, they agreed that the jury would not determine that element of damage if they found a PEPFA violation. That front and back pay would be determined by the trial judge. That was what Mr. Husky refers to as a stipulation. And it was an agreement. It was reflected in the verdict form, which again did not have a place for front or back pay. It was reflected in the motion for front and back pay, which was filed in January of 2017, the hearing at which the county attorney attended. It was discussed in the motion for a new trial that was filed in February. And ultimately, there were discussions between the county attorney and Mr. Spinning over what had happened. And there was enough information for the county attorney to make a decision that he needed to investigate. Mr. Husky referred to the fact that the standard for accrual in legal malpractice cases was adopted from case law precedent that for medical malpractice cases. And I think there's language, and it's a MedMal case, but the Woodruff v. Walker case says that the plaintiff has constructive knowledge of their claim if they have enough information that would alert a reasonable person of the need to investigate the injury. So the two prongs for accrual are an injury and a legally cognizable injury, which I think everybody agrees, and I think the county has conceded in its brief, would be no later than July 7th, 2017, when the judgment entered. But then the knowledge component is what the county is concerned with here. And the standard is when they have enough knowledge, enough information to alert a reasonable person of the need to investigate the injury. And the county attorney began investigating prior to the filing of the notice of appeal in September. Not only did they have enough information, but they did in fact investigate. With regard to the type of knowledge that was necessary, the county would like the court to focus on specific facts. However, the case law is very clear, beginning with the Cherry versus Williams case. And this is a quote. The plaintiff is deemed to have discovered the right of action if he is aware of facts sufficient to put a reasonable person on notice that he has suffered an injury. There is no requirement, and I'm quoting these out of order, but this is all from the Cherry case. There is no requirement that the plaintiff actually know the specific type of legal claim he or she has, or that the injury constituted a breach of the appropriate legal standard. It's really it is knowledge of facts sufficient to put a plaintiff on notice that an injury has been sustained, which is crucial. So really, I think that under the case law, the county's knowledge of the judgment entered against it is really, that's knowledge of the injury, which I believe is sufficient for accrual. They had knowledge sufficient to put them to cause them to investigate. They incurred expense in doing so. And of course, the case law says that a mere inconvenience is sufficient to trigger accrual. Continuing representation doctrine, the appeal doctrine, both were rejected by the 2017 Tennessee Supreme Court case of Story versus Bunstein, and can't help.
Mr. Brown, do you believe the alleged error is the oral stipulation allowing the judge to determine front and back damages? Or, and I don't know how to say this, is it the county's lack of knowledge of the oral stipulation? If that makes any sense.
The oral stipulation was really as to the form of the verdict form. As to what would the verdict form look like? Would there be space on it for the jury to award front or back pay? That's what the stipulation was that would not be on the verdict form, but would rather be reserved for a judge to determine later. So the county had knowledge of what was on the verdict form. And they litigated that question of whether the verdict form was confusing, whether only identifying, it said that it asked the jury to determine whether there was a PEPFA violation, period, without spelling out the different potential PEPFA violations. And the jury said yes. And based on that, and the trial judge then awarded the front and back pay later, and that was reviewed by this court, which affirmed that judgment. So I think that the question, or what Mr. Husky refers to as a stipulation, was that front and back pay would not be on the verdict form. And that question was clearly known to the county no later than when he looked at the verdict form. And certainly I would say probably earlier when the county attorney attended the hearings on the motion for a new trial and, arguing that the verdict form was confusing. And the motion for the award of front and back pay that was argued, at which the county attorney attended, all of that turned around the fact that the jury had not, that no award of front and back pay had yet been made because it was being reserved to the trial judge, which is the stipulation.
So there's no question as a matter of law that if a plaintiff in this type of action prevails on the underlying claim of, yes, there was a violation, then it's a matter of law. The person is entitled to at least present their claim for front and back wages. Whether or not they get one or both is still up in the air, but they've absolutely got the right to present that claim.
I believe that that's right. I mean, that's the part of the nature of the damages that they would be entitled to for a PEPFA violation if the circumstances fit. That question.
The fact that there was not a blank line for front or back wages on the jury verdict form, then it's a matter of logic and certainty. It would have to be decided by somebody later, obviously, in this case, the judge. Yes.
And that was made explicit in the motion for an award of front and back pay that was filed on January 25th, 2017. And, again, the hearing on that was one at which the county attorney attended. Just very briefly, and I may not use all of my time unless the court has questions for me.
Well, you can save it for an argument before the eastern section of the court.
They'll appreciate that.
Yeah.
Well, I'll be happy to take it.
All right. When Mr. Husky, we can work out an agreement here.
When the county attorney went to the clerk's office after the adverse judgment and before the filing, the notice of appeal was filed. Present in that court file for his review were the complaint seeking front and back pay, the order reserving front and back pay to the judge, post-trial briefs regarding the verdict form, and the motion for an award of front and back pay. And of course, the verdict form itself was all there in the file for review by the county attorney in 2017. The county does raise on appeal the question of concealment. Again, that was raised for the first time on the motion to alter or amend the trial court's order on the motion to dismiss, and so it's not proper for argument here. And then our final argument is just that there could not be malpractice because the case law supported determination of the front and back pay by the trial judge. And so that is the fact that the county attorney is focusing on, that he claims he was not aware of until the appellate court decision, that is not malpractice. Again, there's plenty in the trial court record and argued at the hearings at which he was present, which discussed this question. But I think that even if it were somehow kept from the county's knowledge until the Court of Appeals opinion, the fact that that front and back pay were to be determined by the trial court, it's not a fact knowledge of which would trigger accrual. And I'll let my 2 minutes go, unless the court.
All right, thank you, Mr. Brown. Mr. Husky, we'll now hear from you on rebuttal.
Your Honor, I talked in my brief about some baiting and switching they're doing, and I think we had a little of it today about the form. There's not an issue that's raised by the county about who should have awarded the front pay or back pay if there was a finding to justify that. The issue was, and the issue is in the case, that nobody, neither the jury nor the judge, made a finding of that the layoff, which everybody agrees was the only alleged PEPFAR violation that could warrant a award back wage damages. It would be fine. The stipulation for the judge to do it or the jury, that's not the issue. The issue is the stipulation was not, as counsel would indicate, just that the judge handles the award of wage damage as appropriate. The fact is that the stipulation, as found in it, set forth in the Court of Appeals opinion in the forgetting her name, the Keeling case, found that the stipulation was that if the jury found a PEPFAR violation, if the jury found that her layoff was a PEPFAR violation, then fine, good. It'd be right for the judge to go ahead. But the situation this puts us in is nobody's made a finding that the layoff, which is the only alleged PEPFAR violation that could generate this, was made by anybody. The jury didn't find it. You can look at that form. They weren't asked to find it. And the judge just went forward and said, the jury's found a PEPFAR violation and awarded. Matter of fact, the judge was even saying the jury found it. That's what prompted me to look at that. And so there's not the fact that they stipulated about who would award those damages if appropriate. It's not an issue. It's the fact that they were going to award those if it was a PEPFAR violation of any of the 11 or 12 that was alleged. Somebody had to find it. Nobody did. And the Court of Appeals in the Keeling case pointed out, but that stipulation says if the jury finds a PEPFAR violation, the judge goes forward. That's on page 18 of the underlying opinion, and it's attachment 1 to the appellant's brief. Now, the other thing is addressing is about we were investigating. Put simply, if I have a valve go, if I have a radiator cap blow off on my car, and I go to a parts store, I'm not going to look at the motors or the fuel filters. I'm going to just look for a cap. You don't go through the whole store for that. Post-trial proceeding, Mr. Spinning was arguing nobody's made a finding that the layoff was a PEPFAR violation, and that's the only one that can support a wage verdict. The judge says, no, the jury found the layoff was a PEPFAR violation. You don't need to go read and search for a court file and it's spinning through to find out what the jury was asked and what they said. So we went to the clerk's office. I went and asked for.
All right, Mr. Husky, you need to wrap up. Your time is up. So
that's it in simple. We looked and saw that Carl Spinning was right. The jury hadn't found, wasn't asked to find. So, and all these allegations in the complaint are assumed it true. He might be arguing, he's arguing this like he was arguing a summary judgment. He had affidavits to contrary, but the complaint is taken as true, every word of it. Just
all right. Thank you, Mr. Husky and
Thank you,
Mr. Brown, for your arguments. We will take this matter under advisement. Ms. Lindsay.
This Honorable Court of Appeals of Tennessee is now in recess.
All right. Thank you, counsel, and you are free to exit the Zoom meeting.